A shareholders agreement is like a business marriage contract. So like a marriage contract, you want to cover how certain situations will be handled if those situations arise. It basically covers all the what-if questions in a corporation. Today, I'm going to talk about the 4 most important questions that you want to keep in mind before you sign your next shareholders agreement. These are the 4 most important elements inside the whole entire agreement. The agreement can be fairly lengthy. If ever you've signed one before or you're about to sign your next one, it's something that could be around 30 pages to 90 pages, depending on how many shareholders and what types of clauses you have in there. But these 4 questions are always addressed. And like I said, they're the most important questions. One of the first most important questions that the shareholder agreement always covers is what will happen if a shareholder wants to leave the corporation. Here, what we'll usually do for our clients is that we input in what's called a right of first refusal. A right of first refusal essentially is that the shareholder that wants to leave the company will be obliged to offer their shares to all the other shareholders in the company before anybody else, so before they can offer them to a third party. The way that this works is that they will send a notice to the other shareholders and they will let them know that I want to sell my shares, and within 30 days, the other shareholders will have to respond and say if yes or no, they will be buying the shares. If more than one shareholder buys the shares or wants to buy the shares, then it's going to be split up pro rata between them. What pro rata means is essentially going to be split up depending on the number of shares that they already have. So they always keep the same shareholding that they already had inside the company. That's how it works if a shareholder says yes, they want to buy the shares. Now it's possible that all the shareholders say, actually, no, we don't want to buy the shares. And in this case, the selling shareholder can go ahead and offer their shares to a third party at that point. One thing that you always want to keep in mind in this clause is that you always want to make sure that your shareholder agreement has a non-competition, non-solicitation, and confidentiality clause. What you want to do here is you want to prohibit a shareholder from leaving the company and then opening another company in the exact same business and soliciting your employees and your clientele. So you want to make sure that there's always those clauses inside the shareholders agreement to protect the corporation. What we do with the right of first refusal is that essentially it prevents from having an undesirable third party enter the business. You don't ever want to have an undesirable third party come into the corporation. So what we'll do at this point is that by offering the shares to the other shareholders first, they will be allowed to purchase the shares before anybody else. So they're preventing from another party coming in and maybe they don't like them, maybe they won't agree with them very well. The next question that's always covered inside the shareholder agreement is what happens if you want to kick out a shareholder. There's 2 different situations where you may want to kick out a shareholder, both of them varying in their degree. The first one is you want to kick them out, but you're kind of on friendly terms. In this case, we'll do a simple transfer of shares. The parties will agree on a certain price and we'll just transfer the shares. If you're on a end-all be-all, you absolutely cannot agree, you absolutely don't know what to do and you must kick this person out, there is always what's called a shotgun clause. You don't use the shotgun clause if you can agree with this person in an amicable fashion. It's a very aggressive clause to use. The way that it works, the shotgun, is that it's a buy and sell clause. The person that wants to kick out the shareholder will inform that shareholder by notice that I am offering to buy your shares at a certain price, but at the same time I'm also offering to sell my shares to you at that exact same price. That's what makes it fair. That shareholder can either choose if they want to sell their shares to this person or if they want to buy their shares and then that person leaves. It works in the same way as the right of first refusal. They get a notice, they have 30 days to respond if yes or no they're going to be buying or selling their shares. And in either case, the party that will be buying or selling will have to provide the other one with a letter of credit that shows that they're able to purchase those shares. That's the way that the shotgun clause works. Like I said, you don't use this clause for fun. This is a very aggressive clause to use. So you want to make sure that if you are utilizing this clause, it's because you absolutely cannot come to any type of agreement with the other partner that you want to kick out. The next question that you always want to keep in mind when you're signing your shareholders agreement is what happens if a third party wants to come into the corporation. There's 2 different situations here. One of them is called a tag-along and one of them is called a drag-along. The tag-along is also known as your piggyback rights. This is a situation where a majority shareholder informs all the minority shareholders that, by the way, a third party is going to be buying my shares. Imagine if you have a company where you have 80% majority shareholder and you have 20% minority shareholders. How undesirable is it for a 20% minority shareholder to now have a third party enter into their business at 80%? Not very fun. The way that it works is that the minority shareholders can piggyback on that sale. They can tell the majority shareholder that you cannot sell your shares unless that third party also buys our shares at similar terms. That's what a tag-along is. Now the drag-along is the exact opposite. So here the majority shareholder is actually going to be dragging the minority shareholders. The way this works is that let's say the majority shareholder wants an exit strategy out of the company and they want to give away 100% control of the company. But the third party doesn't want to buy a company with a bunch of minority shareholders. What the majority shareholder can do is that they can actually drag along the minority shareholders into the sale and have them also sell their shares. The reason why we have this clause is because we don't want to have minority shareholders create a lot of issues for the third party that wants to buy the corporation or buy control of the corporation. And you also don't want to prevent the minority shareholders from trying to block the sale by virtue of the fact that they are minority shareholders. This is something that's really important. The next question that's always covered inside the shareholders agreement is what will happen if a shareholder dies? This is the most important section inside the entire agreement. If a shareholder dies in the company, you can have different ways that you can go about it, but I'm going to give you today the most common way that we deal with it. These shareholders will each subscribe to a life insurance policy in which the corporation is the beneficiary, and each life insurance policy will be held in their name. When they die, it will be deemed that the sale of the shares happened right before their death, and all the contracts will be drafted afterwards. The way that it works is that the other shareholders will use that life insurance to purchase the shares from the deceased shareholder. If there isn't enough money with the life insurance, they will have to pay up the rest of the money. And if it's too much money, they would give the rest of the money to the heirs. That's usually the way it works if we have a shareholder that dies inside the company. These questions, like I said, are not the whole entire agreement, but these are the most important questions that you'll cover inside the shareholders agreement. If you've never drafted one and you need to draft one or you're not sure how to go about it, you can always call us or contact us at the office. It would be our absolute pleasure to help you.